Good morning, Your Honor. Yes, we are on the record.
Thank you very much. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I'm not sure if both counsel have been through this. I know that Attorney Garg has been through this many times. But how we do this is when you're arguing, a justice may raise their hand, either their virtual hand or their real hand. If you see that, please get to a point in your argument where you can pause, and then I'll ask a question. What tends to happen is we get in the queue, so when you see the hand right away, if you're in the middle of a thought, please finish that thought, get to a logical break point, and then we'll ask the question. Are counsels ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. Appellant, please identify yourself for the record and let us know how much time you wish to reserve for rebuttal.
May it please the court, my name is Vishal Garg and I represent the defendant appellant DANTE HUGHES. I would like to reserve 10 minutes for rebuttal, please.
Thank you. As usual, Senior Associate Justice McDonald will be our timekeeper. He'll hold up signs saying 5 minutes, 3 minutes, 1 minute, and your time is up. You may proceed.
Thank you, Your Honor. The first issue in this case concerns the sufficiency of the evidence with respect to self-defense. The state has the burden of disproving self-defense, and its burden is a burden of persuasion, not a burden of production. However, in order to meet the burden of persuasion, there must be some evidence in the record from which the state can argue its position. To start with here, there's no conflicting evidence about what occurred in the moments immediately preceding the shooting. The only evidence on that came from the defendant. He testified that he saw Gingerella reaching to his waistband for what the defendant thought was a gun. In this case, the state presented nothing to contradict the defendant's account. That differentiates this case from, I think, the typical self-defense sufficiency case.
Yes, counsel, thank you very much. You said there's nothing in the record?
There's nothing in the record to contradict the defendant's testimony about Gingerella reaching into his waistband immediately before the shooting.
Except there's evidence that there was testimony that from the people who knew the victim that he didn't have a gun that day.
Correct.
And so we know that the defendant thought that the victim may have been reaching into his waistband for a gun, but no gun was found, correct? That's
correct.
And the fact finder could disbelieve that his story that he was, or his version of events that somebody was reaching for their gun.
Yes. However, I don't think that that is the end of the story.
Okay.
And part of the problem here is that the defendant doesn't bear the burden of showing self-defense. He bears an initial burden of production, and then the state has the burden of disproving self-defense beyond a reasonable doubt. I think it's important to recognize that there are several cases in which this court has framed that burden in terms of proving a lack of justification as opposed to simply disproving a defendant's account. And I would cite to State v. Clark, and I believe that this is cited in the brief, but I don't think it's specifically quoted. This court said that it was talking about jury instructions on the issue. A defendant is entitled to proper jury instruction on the elements of self-defense, quote, so that the jury may ascertain whether the state has met its burden of proving beyond a reasonable doubt that the assault was not justified. So evidence undermining the reliability of the defendant's testimony is not the same as evidence that the shooting was not justified.
Well, what about this, counsel? These things the state says it showed, that no weapon was found near the victim or after the shooting. None of the state witnesses were familiar with the victim and saw him with a weapon. I mean, who were familiar with him, saw him with a weapon or knew that he carried one. One observer testified the victim never touched the defendant, and he de-escalated the argument between the defendant and the victim. The defendant was in a heightened state of aggression, and the nature of the victim's injuries, one of the pellets penetrated from behind the victim. What about that?
So I think there are a few things there that I want to unpack. So first is, as far as the existence of a gun, the defendant never testified that he saw a gun. He saw Gingerella reaching into the area where the defendant believed he would have carried a gun. That, in light of the threats,
that can be anywhere. That can be a waistband. That can be a pocket. That can be an ankle. Why is that enough? He saw the defendant's hand near the defendant's body. The jury could believe him or disagree with him that it was reasonable for him to believe there was a gun present.
Right. And I think that gets back to the issue of the state needs to not just say that the defendant's testimony is not believable, but needs to prove affirmatively or be able to argue affirmatively that the defendant was not defending himself.
But you can use the defendant's own testimony to do that. You don't have to proffer anything if the defendant gives you all that you need.
I think that's correct. I don't think that that's true in this case. So as a general matter, I do think that that's correct.
I'm sorry, counsel. Please finish answering my question, but I see there's a lot of other justices. I'm very sorry about that.
Sure. And I just want to quickly address a couple of the other things you said. So I think the most important thing here is the testimony from the expert about the location of the shots. First, when you look at the photos, the shots are not actually in the victim's back. And these are exhibits 162 and 169, state's exhibits 162 and 169. They're in his side. They're closer to the back of his body than the front. But the medical examiner who testified did not produce a reconstruction of the events, was not able to say whether or not the shots, he was asked specific questions about the orientation of the victim at the time of the shooting and wasn't able to say anything about it. He specifically said that that was something that he wasn't able to do. And so for the jury to draw inferences about the orientation of the victim in the lack of any testimony from the medical examiner would have been unreasonable. And the reason is that just the fact that we have a medical examiner testifying about this subject matter shows that everyone agreed at this proceeding that this issue was outside the ken of the average juror. And so it's unreasonable for the jury to draw inferences that are outside of its competence.
Thank you, counsel. I appreciate that. The order here says Justice McDonald and Justice Kahn, but I believe Justice Kahn had her hand up and it went down. So I'm going to call Justice Kahn first and then Justice McDonald.
Thank you, Chief. I did have my hand up and I took it down because your questions were around the questions I wanted to ask counsel. I just have a quick follow-up to the Chief's questions. You seem to be focused on the time period just before the shooting, but the jury is instructed that they can look at a broader picture. They can look at, what happened before the shooting, what happened after the shooting. That informs their decision of whether the defendant, because it's an objective subjective test, whether the defendant was acting in self-defense. And there are other things, the state, of course, said he had a duty to retreat. And, there are 4 elements to defense that the state can disprove. And then there are exceptions to self-defense that the state can also prove. But my question is more, again, you seem to be focused on what happened just before the shooting. And you said, in this case, it's unlike other self-defense cases. Actually, this case is unique because you do have witnesses. In most self-defense cases, there are 2 people involved, and one is dead, can't talk about what happened, usually, the alleged victim, and the defendant who is claiming to have acted in self-defense is the only one that can talk about what happened. And so jurors have to draw inferences from other evidence. In this case, there were 2 bullets, as the chief pointed out. The one in the back that went through the groin was clearly shot from the back and in an upward motion. to suggest that he was either on his way to the ground or already on the ground when shot. The other one went through the back of the shoulder slightly, and then the only bullet that was forward was the abdomen. And it's unclear, I know, from the reports, medical reports, which bullet went in first. But in this case, there are witnesses who watched the fight between the defendant and his girlfriend and what happened. So are you saying that the jury could only look at what happened moments before? Or can they take the totality of what happened and also, the duty to retreat and your client's actions thereafter? Not as consciousness of guilt, but what he did after. To Canada.
I believe that can only be taken as consciousness of guilt. So setting aside, let's see.
Why is that? Why only consciousness of guilt? Why can't the jury look at what he did, cutting his hair, changing his clothes? That would be inconsistent with somebody saying, look, I had no choice. I shot him in self-defense. I felt I was going to be killed.
So I disagree that would be inconsistent with it. However, I think the relevance of that is consciousness of guilt as opposed to what happened.
Can't a jury, and I'm not sure if the state argued this, can't a jury infer, look, if somebody shoots someone in self-defense, they may run from the scene, right? But the next thing you should do is pick up the phone and call the police and say, look, this guy threatened he was going to kill me, and I shot him in self-defense. You don't run and hide and change your clothes and cut your hair. And why can't the jury consider that?
I think it can be considered as to whether the state has met its burden. But ultimately, I think there needs to be specific evidence from which the jury can either infer that, or specific evidence either contradicting the defendant's account or showing that account was not what happened. And I do want to refer the court to, I believe it's footnote 6 in my opening brief that goes through, I think, almost all of the self-defense sufficiency cases from our courts. They've always been decided on the basis of contradictory evidence, where the jury could believe one account and disbelieve the other. And that's not what happened here. There's only one account of what happened. There's no dispute that the defendant and Gingerella were in a heated argument immediately before the shooting.
But counsel, in every self-defense case, there's always one account because the other person is presumably dead in most cases and can't talk about what happened. And there aren't other witnesses. So isn't the evidence here about the nature of the injuries inflicted, how the bullets went in, what your client did, doesn't that all go to either supporting or contradicting his claim of self-defense? And that's my last question. I noticed also Justice Dorias has had his hand up, and I don't want to take up all the time. So if you can just answer that, and I'll yield back to the chief after that.
Sure, thank you. And I apologize. I'll be really brief with that. I think that the evidence about the shooting, the location and direction of the bullets could conceivably support it, but where the state's expert didn't support any of the state's arguments, I don't think it was reasonable for the jury to draw inferences or draw the sorts of inferences that would need to be drawn to arrive at the conclusion that the defendant wasn't acting in self-defense or that Gingerella was on the ground or going to the ground at the time of the shooting.
Thank you, counsel. Thank you, Justice Khan. Something unusual is going on with my my program here. Hands are appearing and disappearing, and I don't know if it's the program or the justices are dropping their hands. Justice McDonald, you had your hand up. Do you have a question?
I'm all set, Chief.
Thank you. Justice Dario.
Thanks, Chief. Attorney Garg, there was evidence that his uncle said he said that that the defendant said that this guy wasn't minding his own business. Victim. Who'd that come in through?
That came through the uncle, and that's not what the uncle said. What the uncle said was that the defendant told the uncle that the defendant told Gingerella to mind his own business.
That the defendant told Gingerella to mind his own business. Okay. And that seems, the defendant told Gingerella to mind his own business.
Right. And then
seems
before the
pretty
shooting.
Before the shooting, yeah. I mean, I guess you're focused on, who saw what and who reached for what in the waistband. If the explanation he gives to the uncle pretty contemporaneously as he's headed, to Canada is, I told Gingerella to mind his own business. Isn't that pretty powerful?
No, I don't believe so. I mean, there was a dispute between the defendant and Gingerella over the defendant having hit his girlfriend. Specifically, Gingerella and I forget who the other person was now, attempted to pull the defendant off of his girlfriend.
Who called the uncle? Who called him? The state or
the state called him.
Okay.
And so I do just want to clarify. I mean, I think the state characterizes that testimony as saying that the defendant shot Gingerella because Gingerella wasn't minding his own business. But when you look at the uncle's actual testimony, that is not what was said.
Well, but okay, this is the last thing I'll say. See for your reaction. Give me your reaction. He didn't say, and I shot him by accident because I thought he was coming at me with a gun. He didn't say that.
I believe that's correct.
Okay.
At least there's no evidence that he said that. And I do want to move on to the second issue in this case concerning manslaughter. Unless there are further questions on the self-defense issue.
Justice Keller, then Justice Ecker.
Thank you, Chief. I wanted to focus a little bit on how he went into his car, went into the glove compartment to grab his gun. Couldn't the jury draw an inference there that he was already contemplating taking a shot at somebody? Because that was before he claims he saw the victim with reaching into his waistband. I know he had another explanation for that, that he didn't want the girlfriend to get arrested for drunk driving and have the police find the gun in the car. But the jury didn't have to accept that. And, that could just be an additional showing that he was deliberately acting in a very sort of reckless and risky manner. And maybe not specifically intending to shoot any, but that kind of added to his recklessness and his lack of control that night.
And I think that the jury can draw the inference that it was a reckless action, but I don't think it is sufficient to disprove self-defense.
All right, thank you.
May I, Chief?
Yes, I'm sorry. I must have hit the
No,
button.
I'm the hands. So great. So good morning, Counsel. I want to ask you about the your second issue, which personally to me is more interesting than the first. So I hope you have a little time to talk about it. My question, the only question right now I want to ask you is on the who has the burden of proof. If you look at the cases like Ashram, and if you look at the cases that say that there's a presumption of prejudice, one would almost think from that, necessarily that the state has the burden of proof to show that there was no prejudice. However, there is this. It was the case cited 320 Con, I forget, by the state that says that if the trial court isn't implicated in the wrongdoing, then it's the defendant who has the burden. And I just don't know how those two things fit together.
Sure. So I think there are a couple of things here. So first, I think that sorry, there are just I want to make sure that I have that I'm thinking through the issue correctly. So first, I think it's important to note that the parties agree that the state bears the burden. At least that's what I took out of the state's brief. The state seems to indicate that the state conceded at the proceeding below, or that the trial court in the proceeding below correctly allocated the burden because it assigned the burden to the state.
Well, I guess it's the state against Roman case that the state cites. You know, and I don't want to waste your time going through the state's theory. They'll explain that, however. But they quote from Roman at the top of page 30 of their brief. They say that the trial court cited Roman saying that the defendant bears the burden of proof of proving actual prejudice resulting from the misconduct when the state when the judge isn't implicated in the misconduct. I looked at Roman, it seems to say that, but it doesn't talk to this other line of presumption of prejudice cases that I saw. Can you clarify that? I know your time is up, but I think it's an important issue.
Yes, and I'd ask to just start eating into my rebuttal time because I do want to make sure that I answer this. I think it's important to look at the fact that Roman actually relies on I think it's State v. Barrios for the burden shifting rule, which is where this court had articulated it. And Barrios makes clear that in order for the presumption to apply, the defendant must make a showing that the extraneous influence existed and pertains to a matter before the jury. And in Roman, sorry.
No, I don't want to cut you off. I just want to conserve your time. I mean, it sounds like we should look back through Barrios, and there's a line of cases. Your position is that the state bears the burden upon your initial showing, and the burden is to show that there was no prejudice beyond a reasonable doubt?
Correct. Here, I don't believe the state can show that because of the equivocal nature of JB's testimony. He was asked on 4 separate occasions about how the external information might have affected his ability to decide the case. I think it's important to look at that actual testimony because the trial court keeps questioning him after he gives the quote unquote wrong answers until he gives the correct answers. And I think that's a problem for the trial court to then turn around and say, well, I'm not crediting these answers because they were non-responsive. The first time that he's asked whether the external information affected his ability to decide the case, he answers, yeah, it did. And then he talks about how the manslaughter conviction wasn't the outcome that he wanted. But he clearly is giving a responsive answer there. And so the trial court to find that it's non-responsive and therefore it doesn't count towards him being equivocal about the impact of this on his thinking, I think is incorrect, and there should be a remand for that issue. And if there are no further questions on that at this time, I will reserve the remainder of my time for rebuttal.
You have 7 minutes.
Thank you, Your Honor.
Thank you, Counsel. State Attorney.
Good morning, Your Honors. For the record, my name is Jonathan Souza. I'm a Deputy Assistant State's Attorney from the Appellate Bureau of the Chief State's Attorney's Office, and I represent the state of Connecticut in this matter. May it please the court. This court should affirm the judgment of conviction and reject the defendant's request for a new trial. With respect to the first issue, I'll be very brief. The defendant's entire self-defense claim is predicated on this movement that he alone testified the victim made immediately prior to the shooting. And the jury, in consideration of all the evidence that the state presented, apparently did not believe that version. That really ends ends the claim right there. The state's burden is to disprove, not to prove the opposite. So contrary to what the defendant argues on appeal, we do not have to present direct eyewitness testimony of someone who said they saw the victim standing still or anything that would directly contradict the defendant's testimony. That's not the state's burden. We presented more than sufficient evidence for this jury to conclude beyond a reasonable doubt that the defendant was not justified in shooting the victim. And that included the defendant's conduct and statements before and after the shooting, the quantity and nature of the victim's wounds. As the Chief Justice noted, the absence of any weapon found on or near this victim, and overwhelming evidence of the defendant's actions from which the jury reasonably could infer a guilty conscience. Fleeing to Canada, changing his appearance, deactivating his cell phone, activating a new one, trying to conceal his movements, etc. So based on all the evidence presented, the jury reasonably could have concluded that either the defendant did not reasonably believe that the victim was about to use deadly force against him, or that he knew that he could have retreated with complete safety prior to shooting the victim.
My apologies, I was looking at my notes. Justice Keller.
Thank you, Chief. Good morning, Attorney Souza. What about the evidentiary principle that disbelieving someone's statement doesn't necessarily mean that the jury can conclude the opposite is true?
That's correct, Your Honor, and we're not asking the jury to do that here. We're not asking the jury to infer, based solely on its disbelief of the defendant's testimony, that the victim did nothing prior to the shooting or did not make a motion that would cause the defendant to believe that he was had to act in response to imminent threat. We're not asking that here. We're asking the jury to infer, based on the evidence we presented at trial, that the defendant's version is not credible, that he was not justified in shooting this victim.
Did any of the witnesses see the victim leave the immediate vicinity of the car before the shooting occurred? I was just wondering if anyone saw him walking towards the defendant or walking away from the car towards the bar entrance.
I don't recall any specific testimony regarding what direction the victim was walking in. There was testimony from, I believe it was Ms. Gonzalez, that the defendant was trying to get around the victim to reapproach his girlfriend, whom he had previously assaulted. But in terms of the victim's movements or where he was walking, I don't recall any specific testimony to that.
All right, thank you.
Justice Daria.
Thanks, Chief. I want to ask you a question about the duty to retreat in this case, and I understand that that's not the only way that you could disprove self-defense, but let me just indulge me with this. Is there no question that the victim pursued the defendant after the defendant had begun to walk away? Is that pretty clear?
As far as I'm concerned, Your Honor, there was no testimony that the victim was pursuing the defendant after that. I know he pulled the defendant off of his girlfriend, and then there was some sort of verbal exchange between the two. But as far as
I understood, do you correct me or your opponent will? At least I thought I understood that the defendant moved away, walked away, and he turned around to come back. I think because of something that the victim may have said. So pursue may not be the right word, but maybe he came back because the victim engaged. Am I wrong about that, or was it more equivocal than that?
So the testimony from the defendant was that he initially walked away from the area where the victim was, got to about a 15-foot distance, and then for reasons he did not explain, turned around and faced the victim once again. I don't necessarily recall if that was because of something the victim said, but we do know from the defendant's testimony that he did turn around and face the victim after initially walking away towards the school, which abuts the pub parking lot.
Okay, so can you sort of precisely when do you think he had a duty to keep on going? I mean, he was retreating, he was walking away, but apparently it's only when he turned around, he claims, I understand he claims that he saw the victim going for his waistband. At that stage, I mean, that's where the rubber hits the road is does he have a duty to retreat, or are you suggesting that, can he reasonably retreat, or are you saying he just should have kept going and never turned back and you would have known nothing about him reaching for the waistband, which seems a little fanciful?
Well, Your Honor, the latter part of Your Honor's question is what the state argued here, that because he was already retreating and walking away, he had a duty to keep going. I don't believe, if I understand Your Honor's question correctly, I don't believe the duty to retreat exception focuses precisely at the moment where the defendant claims he saw a threatening gesture made. Because in State versus Saunders, this court held that the defendant had a duty to retreat based on the fact that he was near a marked exit before the victim even entered the same room and made, according to the defendant, a threatening gesture. And also in State versus Marshall, that's an appellate court case. In that case, the victim was actually chasing the defendant, who was running away. The defendant turned around and hit the victim with a tire iron. So I don't think the duty to retreat exception focuses solely on the precise moment when the defendant claims the threatening gesture was made, based on those cases.
Okay, thank you.
Justice Secker?
Thank you. Good morning, counsel. I'm going to take you to the second issue. If any of my colleagues have questions on the first, I'm sure they'll go back to them. I'm interested in, I guess, two things. First, the trial court's prejudice analysis seems to be guided by State against Johnson, and that's a concern to me because when I look at State against Johnson, the court makes an effort there, I think, to say, look, this is not a juror misconduct case. This is about a courtroom atmosphere case, and the two are different. And I think it even says, although I can't, don't trust me on this one because I'm not certain. It cites to a California case that actually makes that distinction in the context of what the prejudice test looks like. So that's my first question: isn't that a mistaken use? I'm not whether or not it made a difference here. Isn't that a mistaken use of a State against Johnson in terms of the analysis undertaken?
I would agree with Your Honor's analysis of Johnson that it applies solely to juror bias, and whether it was mistaken use or not, though that was unclear because Johnson doesn't say that particular framework would not apply in a jury misconduct context. And
true. So although it's odd to go out of your way to distinguish something if it doesn't really make a difference, but I grant your point, and which exact test should be used may be uncertain. Mr. Garg and I talked about that a little, but that leads to the second question, which is this. So this reminds me a little bit of Batson situation. It's obviously a very different context, but it is about whether we should trust a juror's answers, sort of, or try to figure out subjectively what's really going on in an area where people may have an incentive not to admit what's going on. And so the objective test proposed by Mr. Garg, and that you say you win under anyway, does have something to recommend itself to look at. For example, I know the jury selection task force is sort of recommended. How would an objective observer view this rather than was it really prejudicial, prejudice, animus based? Similarly here, isn't that kind of a test something that might be advantageous, an objective test?
The state would agree that going forward, a set of factors for a trial court to consider in assessing prejudice would be useful. I don't agree that the Harlan typical juror test is appropriate because that case doesn't account for the fact that when a juror brings in extraneous information into the deliberation room, that automatically creates a presumption of prejudice. I think the Mayhew test that Attorney Garr cited would be more appropriate because that one focuses both on the objective inquiry and allows for an open-ended inquiry. Specifically the fifth Mayhew factor, which says any other relevant considerations the judge may glean from the Brown hearing. So going forward, yes, absolutely. I think it would be advantageous to help for a trial court to have a set of relevant factors to consider. I don't think it should be a rigid test because each example of juror misconduct or juror bias has its own factual nuances that need to be accounted for. In this case, Judge Youngblood did not have the advantage of these tests below, and therefore I don't think we can find error based on what she did solely on that basis. So
can I ask you? Okay, this is my last question, I think. Just can you then apply what? Can you tell us why? So let's assume that JB, at least in an objective, in my view, which is an objective view, of course, showed some prejudice or showed that he was really doing his own thing. He was out there doing his own thing. Does that, even if we found that, but that his own thing didn't affect any other jurors, right? Let's say that those two conclusions hypothetically are both true. What's the outcome there? If one juror went off on his own, but the rest of the jurors didn't?
I think it would depend.
I'm sorry, go ahead.
So this actually goes back to Your Honor's initial question about relying on a juror's assurances during an evidentiary hearing. It would depend on what evidence is produced during that hearing. In a court that sees each juror testify live in person can come to credibility assessments and factual findings as to whether this one juror who went outside the record, which he wasn't supposed to do, whether his misconduct had any likely potential effect on the entire jury's ability to reach a unanimous verdict.
So we asked about the jurors, not the juror. We asked about the entire jury rather than the one individual. One bad apple doesn't spoil the whole bunch. Is sort of your point, I guess, or no?
Well, I mean, he can if he brings it into the jury room and it's discussed, and obviously the other jurors are exposed to it. Absolutely, it can affect the entire jury process. That just didn't happen here, according to the factual findings that Judge Youngblood made.
Thank you, sir.
Justice Khan.
Thank you, Chief. I have two quick questions, Attorney Souza. The first question is about this issue. In this case, the court did what we hope trial judges do, which is conduct an immediate full evidentiary hearing, calling each juror individually to determine what, if any impact it had on the jury and whether they were able to follow the court's instructions. And then the court made findings of relating to that and prejudice. And my question to you is, once the court does that, conducts an evidentiary hearing, can make that credibility assessment, listening to each juror under oath, answer these questions, aren't we bound to accept those findings unless they're clearly erroneous based on the record?
Yes, Your Honor, that is the state's argument here. I mean, both counsel knew from the outset of this inquiry that Judge Youngblood was going to be conducting a full-blown evidentiary hearing, that she alone would be examining these jurors and would see them in court and could assess their demeanor, and that therefore everybody knew that the court, or it should come as no surprise, that Judge Youngblood would make factual findings and credibility assessments based on what she saw or heard during that hearing. And
in this case, she consulted counsel and asked them for questions and input as to what she should ask, and even called JB back to do follow-up questions as a result of the defense's request, correct?
That's correct, Your Honor.
Okay, so you've answered my first question. My second question goes back to issue 1, and I don't want to dwell on it, but there was a question that Justice Doria asked your opponent, and I want to hear your take on it. It was an excellent question by Justice Doria, and I'm curious if you agree with your counsel's characterization or representation of that testimony. And that relates to the uncle's testimony that the defendant called either on his way to Canada or when he got to Canada to say, the state's position, I thought, was he told the uncle, I shot him because he should have minded his own business, or not I shot him, but he should have minded his own business, something like that. What was the testimony? What's your take on that? And after you answer that, I'll yield back to the chief.
Yes, Your Honor. So the testimony, and this could be found on page 25 of the July 16th transcript. Mr. Rawls, the defendant's uncle, was discussing the conversation he had with the defendant, and this is what he said. He told them to leave them alone and go mind your own business, whatever the case might be. And the next thing you know, I guess he didn't leave him alone. Now, it's a little ambiguous as to whether Mr. Rawls is making an inference based on what the defendant told him, or if he's quoting the defendant entirely. But according to Mr. Rawls, the defendant did say to him that he had told this victim and Mr. Hoyt, who was the other individual involved, to go mind, that he should mind his own business.
Thank you, counsel. I yield back to the chief. Thank you.
Thank you, Justice Keller.
Thank you. I know that the case law says that how the jury, what went on in the course of the deliberations and what the jurors discussed during the course of deliberations isn't supposed to be admissible in a proceeding like this. But there was testimony from some of the jurors that before they sent the note to the court about whether or not it was proper to look up something in a dictionary, they had already decided against an acquittal based on self-defense, and they were just debating between murder and man one. Was that true? Is that true? That actually came out from the jurors?
Yes, Your Honor. That came from a comment that the foreman improperly made to the clerk.
Do we have to ignore that, or can we use the knowledge of that fact in analyzing this case?
So that's a little unclear from the case law. In Johnson, this court relied on statements that the jurors made that were improperly procured by the trial judge. And certainly the argument can be made, look, the cat's out of the bag, the jury said it, we can't just rely on it. However, in Ilan, this court clearly held that those types of statements regarding the jury's thinking or how they reached a certain verdict should be excluded. They're inadmissible. I think in this,
but they weren't excluded and they were admitted. So isn't it now fair game for us to take that testimony into consideration in determining prejudice?
Well, they were admitted, Your Honor, that's correct. But Judge Youngblood decided that she was not going to rely on this testimony because she made it very clear at the outset of this hearing, I can't delve into these matters. And when JB and others started to discuss them, she told JB repeatedly, I'm not interested in that. I don't want to know what your process was in reaching the verdict. What I want to know is, did you apply this dictionary definition or did you apply the court's instructions as you were told? So
when the jurors sent out their note, she didn't make much of an inquiry. She just told them, no, you can't look up things or something, correct? And this inquiry took place after the trial was over because one of the jurors said something to a clerk when she came back to get her money, correct?
That's correct, Your Honor. Yes.
All right. I was just wondering why, based on that, then now I understand why there was no attempt to just replace JB with an alternate. Okay. Thank you.
Yeah, absolutely, Your Honor. So, the issue of whether these statements from the juror regarding how the verdict was being rendered, Judge Youngblood, in her written decision, found those responses from JB to be non-responsive and did not rely on them, really for two reasons. One, that's not what she was asking him, and perhaps JB misunderstood her questions. And two, she made it very clear at the beginning of this hearing that she was not going to delve into these matters. Perhaps Judge Youngblood was taking an overly cautious approach based on what the practice book provides and prior case law saying that you really shouldn't delve into those matters. But that, I think, was a reasonable exercise of discretion on Judge Youngblood's part.
Justice
All
Eckert?
right, thank you.
Thank you. I suppose that if, this is a better question for Mr. Garg probably, but I'll ask you to. He'd have a better position, the defendant would have a better argument, I suppose, here on prejudice if the jury had come back with a murder conviction. Because then there would be this looming possibility that somebody was actually listening to JB and said, yeah, manslaughter is not the right charge. This was no accident. But here the jury came back with this. It sort of goes to Justice Keller's point, I guess, maybe based on what should have been inadmissible testimony, that at that point the jury was picking between murder and manslaughter one. But it's sort of the same point, but from just deriving it from the end conclusion. Would you agree with me that hypothetically, that if the jury had come back with a murder conviction, he might have a stronger case?
I would agree with you, Your Honor, but I would just note that in order to make that conclusion, you'd have to rely on these improper statements from the jurors about how the process by which they reached the murder conviction, including the foreman's statement about how the fact that acquittal was off the table, that they were only debating between murder and manslaughter. Two other jurors, I believe it was AS and MG, both said that when this incident arose, they were debating the murder and manslaughter.
Well, not necessarily, though. I mean, you could just, putting all that aside, right? You could just say, well, you know, in this situation, and again, this is for Mr. Garg to explain, in this situation, it's really not logically feasible that this fellow's definition of manslaughter made the jury less likely to convict. I mean, oh, I guess your point is they still could have acquitted. So I see.
Or they could have, the jury could have hung. I mean, that's always a possibility in every criminal case. So,
Gotcha. I got you.
Yeah.
Thank you.
Now, opposing counsel made the argument that JB equivocated at times as to whether he was able to follow the court's instructions or whether he could serve impartially. That is correct, he did. However, again, Judge Youngblood did not rely on those equivocal responses because each time JB made them, he interpreted Judge Youngblood's questions to be delving into what he thought was the appropriate verdict here. And Judge Youngblood said, I'm not interested in hearing that. So those were conflicting, ambiguous responses that Judge Youngblood did not rely on, mainly based on her conclusion that they were non-responsive to her inquiry. Again, it's possible that Judge Youngblood maybe took an overly cautious approach here. She made it very clear she did not want to delve into those issues. The state did not rely on them in its brief. We only addressed it briefly in a footnote because the judge did not rely on them. Her ultimate conclusion was based on factual findings and credibility assessments made based on what she saw and heard during this hearing. Which brings me to my final point, which is the defendant's arguments about Judge Youngblood applying the wrong framework or improperly assigning him the burden of showing prejudice. I mean, really, first of all, it's not clear from the record. The defendant, upon receiving this decision from Judge Youngblood, did not move for reconsideration. And it's not clear from the decision itself who bear the burden, according to Judge Youngblood. Secondly, no matter what framework you apply, the judge, after conducting an evidentiary hearing, is going to be guided by her credibility assessments and factual findings. And that's exactly what happened here. The whole point of having an evidentiary hearing based on this allegation is so the fact finder, in this case Judge Youngblood, could draw these conclusions and make assessments based on the jurors' assurances about whether they were able to block this out of their mind and focus solely on the evidence and the instructions. So it's certainly reasonable for Judge Youngblood to conclude here that no prejudice resulted based on this allegation, which was fully inspected and after an evidentiary hearing showed that JB followed, according to Judge Youngblood, her instructions on manslaughter, not this definition. That's all the state has, Your Honor, but I'm happy to answer any further questions from the court.
Thank you very much, counsel. Seeing none, appreciate it. Attorney Garg.
Thank you, Your Honor. I do want to start out just quickly with this issue of the legal standard, which is borrowed from the Johnson case. The three-factor framework from that case is all about partiality and fairness, and not about whether someone's thinking on the case was affected by learning additional information. I mean, it's essentially, were you able to remain impartial? And someone can remain impartial, but still have their thinking affected by information outside of the record. And that's the problem with the court's use of the wrong legal standard. It's that the court's questioning of jurors was all about fairness and partiality. And so when you look at the legal standard, isn't just about the legal standard that the court applied after the evidentiary hearing. It's clear that the court's selection of that legal standard affected how the evidentiary hearing was conducted. And that's part of the problem with the court using the wrong legal standard. I believe that there's a question.
Justice Khan.
Thank you, Chief. My question, counsel, is just about what you just indicated now, which is that the court's focus was on the impartiality of the juries, but wasn't the court's focus here really on, were they able to follow her instructions, or did they rely on this definition? And a lot of the jurors said they shut him down. The minute he brought that definition, a juror shut him down, and then they sent a question out. She wasn't focused on just the impartiality of the jury. She was focused on, were they able to follow the court's instructions? And did this conduct by this juror permeate and impact the other, not only this juror's decision process, but the other jurors? So the court wasn't just focused on the impartiality here. The court was focused on, did they break the court's instructions, or did they follow the court's instructions, right?
I think that was part of the questioning, but she asked each juror she didn't ask, was your decision-making affected by external information? What she asked from each juror was, did the information affect your ability to decide the case fairly and impartially?
Well, she might have asked that question, and she should ask that question, right? That's sort of an overall question. But she also asked the question of, did you follow the court's instructions? The court said you can't, did you rely on this definition? Did you follow the court's instructions? So to suggest that the court focused only on impartiality, and by the way, she asked counsel for questions, right? She asked defense counsel in the state to give input as to what else she should ask. And that's typically, that's a good practice for a judge to do. So are you claiming that she missed questions, or that her questions were insufficient?
Insofar as that is tied up with the claim of the court using the wrong legal standard, yes.
Okay, so what questions should the judge have asked that she did not ask?
She should have asked specifically, did you rely on this verdict? Did you rely on this definition during any of your arguments to the other jurors? Or in your own decision-making?
And counsel, did she ask that of each juror, whether they relied on this dictionary instruction? Are you saying she didn't ask that?
She didn't ask that of JB. What she asked of JB were two things. One, did the dictionary definition affect your ability to sit fairly and partially? And two, did you follow the court's instructions? She didn't specifically ask about whether JB relied on the definition, which is what the prejudice inquiry in this type of case needs to be about.
And are you saying she didn't ask each and every one of the other jurors that question, whether they relied on the dictionary instruction?
I don't know whether or not she asked any of the other jurors that, just because here there's certainly, I'm not disputing that none of the other jurors relied on the dictionary question. I think we all agree that none of the other jurors even heard the dictionary definition. I do think that there are valid concerns about whether or not JB incorporated that definition into his subsequent arguments and whether jurors relied on those arguments.
I see, counsel, I see that Justice Doria has his hand up and you have 3 minutes left, and I don't want to keep going on this, but
thank you, Your Honor.
My follow-up to that is JB was clearly indicated he thought your client was guilty of murder, not manslaughter. So even if he relied on the definition and she failed to ask that question, where's the prejudice when in fact he was holding out for murder and not manslaughter?
It's that a lessened definition of manslaughter would have convinced other jurors to have voted for manslaughter. So the concern here is that jurors are deciding between murder and manslaughter. JB testified he was worried that this was going to end up, jurors are deciding between murder and self-defense. JB was concerned that this was going to end in a self-defense verdict. JB then looks up a definition that lessens the burden on manslaughter because it gets rid of the mental state, or at least requires a lower mental state, and then the jury all agrees on manslaughter.
Counsel, the jury is instructed not to go to self-defense until they find the defendant guilty of either an offense, either the charged offense or a lesser. That's how they're instructed. But Justice Doria has his hand up. I thank you for answering my questions. I'm going to yield back to the chief.
Sure. Thank you, Your Honor.
Justice Doria?
No, thanks, Chief. I'll let Attorney Guard wind up.
Thank you.
And I do just want to get back to the idea of using an objective test because of the impact on Elon, or I'm not sure if I'm pronouncing that right. It's a case from 1975, excluding evidence about the specifics of deliberations. I think this court needs to adopt an objective test and look at the objective factors rather than looking at specifically what happened, because the picture of what happened in this case was significantly limited by the court stopping answers once they happened. And so we kind of have a very incomplete picture about what actually happened in the deliberation room, which is why we ought to look using one of the objective tests. And if there are no further questions, I will rely on the briefs and my argument. Thank you.
Thank you very much, counsel. With that, we will go into recess until the next matter, which is 11 o'clock State versus Torres. Thank you, everyone. Take care.
Thank you, Your Honor.